gentleman from Texas, Mr. Babin.
Thank you, Mr. Chairman, and thank you, witnesses, for being here. Mr. Hopper, you mentioned in your testimony that the draft 2015 WOTUS rule and the final rule had substantial differences within it. Were these differences subject to public notice and to public comment?
Yes, absolutely. That was one of the reasons why the rule was stayed by the District Court of North Dakota and the Sixth Circuit Court of Appeal, is because there was such a substantial difference between the proposed rule and the final rule, particularly with respect to these distance limitations of 4,000 feet and the 1,500 feet and the 100-year floodplain.
Absolutely. So these changes are substantial enough to have warranted this extension period.
Without question.
Yeah, okay. And then also, in a May 29th, 2015 interview with PBS NewsHour, previous EPA Administrator Ms. Gina McCarthy stated the following, quote, "The farmers will know very clearly here that we are clearly explaining that irrigation ditches are not included. We have clearly said in the rule and beyond this rule adds absolutely no new regulatory or permitting issue for agriculture whatsoever." Do you agree with this statement?
No. In fact, I remember writing a blog post saying that the administrator is a prankster, because if she had read her own rule, she'd realize that it's not clear. Even if there's been no change in the exemptions, the statutory exemptions for agriculture, that in itself constitutes a problem, because the agency has a history of defining these exemptions so narrowly as to eviscerate them. For example, there's an exemption for farming. Farming practices should not be subject to Clean Water Act jurisdiction. However, common farming practices are interpreted to mean what's common and ordinary on that particular farm, not what's common and ordinary in the industry. We think that's bogus, undermines the exemption and the statute, and I think we're going to see the same type of thing with any other exemption like ditches.
All right. So we're looking at an enormous overreach by unelected federal bureaucracy.
By any definition.
Absolutely. Okay, and then Mr. Chilton, how can a landowner possibly be expected to know prior to any digging that any water encountered would be, quote, groundwater, and therefore exempt or shallow subsurface, and therefore subject to the Clean Water Act requirements or even to fines?
Well, most farmers and ranchers want to do a good job and earn a living. And you can't really determine when you have an ambiguous, overreaching rule that isn't easily understood. I don't know how you tell the difference between a groundwater issue and whether it's a surface water issue. It's very difficult, and one has to, under the 2015 rule, hire consultants and attorneys to answer that question. Is there a significant impact? In our area, the Santa Cruz River doesn't even reach a navigable river. I mean, it's outrageous the way the county of Pima has to go through all the treacherous paperwork that is imposed on them by the Environmental Protection Agency and the Corps of Engineers when the Santa Cruz River doesn't even reach a navigable river. It's outrageous. And in terms of groundwater, let the state control what is groundwater, what is surface water. It's difficult. It's ambiguous, and it's expensive. We have an overreaching federal government. Remember, the states created the federal government, and now the federal government is ruling with an iron hand, and I hate to say this, Ken, but bureaucrats like you are overreaching. It's outrageous.
Thank you, Mr. Chilton. My time has expired, Mr. Chairman.
Thank you.
Appreciate it.